first of all, thank you to everybody for coming this morning to this webinar, and thank you very much, Shani, for your proposal to present us your research. So just to explain the general framework, this presentation is in the framework of the Blue Justice webinar series, which is a series of webinar within the collaboration between AMURE or lab and the University of Kiel. And we have quite a lot of seminar now developing different kind of aspect of the justice, especially in how to share the resources and the wealth of the ocean. And so in this context, Shani Friedman, you will propose this morning a presentation of the work you are leading in our lab in AMURE about the resources in the zone. And so perhaps can I leave you to present yourself, and then we will be able to begin.
Sure. Thank you very much. I am a postdoc researcher on international law, so my research is mostly legalistic, but also from a more political or social perspective. This research analysis that I'm doing on the benefit sharing from deep sea mining in the area or in the zones, meaning the international seabed, is from more legalistic perspective, but it has also practical implementation, hopefully. And then this is the aspect that I will talk about now. So if it's okay, I can share my screen or my presentation, and I can begin discussing my research if it's okay.
Sure.
Yeah. Just a second. In this presentation, this analysis, as I said, focus on the way that the construction of how to share benefits from deep sea mining in this context in the area, but I'm focusing mostly on the word equitable to try to give meaning and maybe practical modalities for how to equitably sharing benefits from deep sea mining. And here, this connects to theories of justice, which is also connects to the overall outreaching topic of the Blue Justice webinar. So as I mentioned again, there's the context here is benefits from deep sea mining in the area. There's also possibilities for benefits from activities in the extended continental shelf, but in this analysis, I will leave it aside. And this analysis and this presentation based on two assumptions. First, that we will eventually have deep sea mining in the area or in the zone. Otherwise, talking about benefits when there's no activity is rather a moot point. And the second assumption that there will be eventually at least some benefit from deep sea mining in the area. So in this, under these assumptions, this analysis try to ask or find what is actually means to have equitable sharing of benefits, meaning give context and interpretation to a rather a vague term in the UN Convention on the Law of the Sea, which we'll talk about. This is the legal framework. And also review the existing modalities suggested by the ISA, the International Seabed Authority, for benefit sharing in the future. So just to go over quickly on the existing legal framework, we have in 1970s the UN General Assembly decisions designating the international seabed as the common heritage of mankind. We have UNCLOS, the UN Convention on the Law of the Sea in 1982, which adopted on 1994. and also designated the international seabed as the common heritage of mankind. It also provides that the ISA, the International Seabed Authority, has to ensure an equitable sharing of benefits for the benefit of all mankind. And we also have some preferential treatment for developing states, as the convention mentioned that their interest would especially be taken into account in the overall context of benefit sharing. However, we also have some limitations to the existing legal regime. We have the 1994 Part 11 agreement, which is a supplement to UNCLOS. And it also has provision on benefit sharing, mostly on technological transfers and capacity building. And we will talk about it later. Mostly the agreement reduces the options for sharing these benefits. We also have the ISA administrative expenses, which might take away from the benefits that the relevant parties can share. And we have the general, as I started with this presentation, the legal regime or the overall obligation to equitably share the benefits is really generally and vaguely drafted. So it doesn't provide any concrete practical modalities for sharing the benefits. So what I'm trying to look at, or at least draw some comparisons, is trying to look at what equity means in the context of the law of the sea. As equitable comes from the concept of equity in law, we try to maybe put it in context with other previous regimes. So first of all, equity is a concept within philosophical theories of justice. And the purpose of equity is basically to do justice, which can then you understand that it's very broadly constructed. And it has various practices or contexts. So it can be a procedural rules for parties in dispute settlement, how to act, when to submit certain evidence, how to argue certain arguments. It can also be a method for judges to reach a decision in dispute settlement. And in the legal context, especially in international law, but also in domestic law, we have two competing concepts of equity or justice, which one is distributive justice, which are basically the rules on how you divide or allocate resources or welfare. And corrective justice, which also has a remedial aspect, basically correcting or improving a certain situation that is perceived as inequitable. And the method in this analysis, I'm trying to compare other contexts of equity in the law of the sea, mostly in maritime boundary delimitation and the BBNJ, to try to give context or interpretation to the word equitable. So I know, or maybe I should at least say that there are some limitations to this comparison, as boundary delimitation, especially in the continental shelf and the exclusive economic zone, are areas beyond are areas under national jurisdiction rather than beyond national jurisdiction. And in addition, the BBNJ as such does not say the word common heritage of mankind, although it does apply to areas beyond national jurisdiction. Still, I think it's relevant to look at these practices or other regime, because while there are differences, it can also supply us with some insights or some issues that might be relevant to the context of the area and equitable sharing of benefits. So in this case, I think it's very much relevant. So we start with the maritime delimitation, and here mostly I'm looking at the boundary delimitation of the continental shelf, because this is the most cases that we have. The first case that is relevant, we have the 1969 North Sea continental shelf cases, where the ICJ determined that equity is not really equality, or not necessarily equality, meaning that the parties should not have the same area after delimitation. And here the court suggested that equity is as proportionality based on claim. The court connected the area that each party received in the dispute settlement based on the length of its territory or the coast. Or under the assumption that if you have, or if a state have a larger or longer coast, it should not have a smaller area allocated to it in the boundary delimitation. And UNCLOS sort of adopted this analysis or this conceptual framing, because at least in the continental shelf and EEZ, we have the rule of equitable solution rather than equidistance, which means equality, because equidistance means that the parties should receive the same size of territory or maritime zone. And here UNCLOS says we have the obligation to reach an equitable solution, but it doesn't have to be equality. However, in practice, since again, this is a vague term, the courts have developed some method how to delimit overlapping continental shelf. And we see that we start with an equidistance as a starting point. So we start with equality. And then we have some sort of corrective measures or proportionality. So we mean that the court will move the boundary, the provisional boundary line in terms that will fit the proportionality of the areas, the coastal areas of each party. And we sometimes have practice or no, it is not officially articulated. The court has some corrective justice considerations, meaning it will be adjusting the boundary line in cases that it was perceived as inequitable. For something, for example, if one of the parties doesn't have access to maritime zones. So we can draw a conclusion that at least in boundary delimitation, we have distributive justice method based on claim or contribution. Here is the claim to an area or the maritime zone, with some elements of corrective justice in cases that are perceived as disproportionate or inequitable. And then we have the BB&J. And the BB&J, unlike UNCLOS, refer to both monetary benefits and non-monetary benefits. In terms of non-monetary benefits, for example, access to marine genetic resources, we have an element of sharing based on equitable basis, meaning all parties, all states, or all relevant actors will have equal access to the genetic material resources. So we have practical equity as equality. We have monetary benefits, and at least the BB&J suggests a fund for division of the benefits. And here, one of the modalities proposed or suggested is that having advantages for states based on their capabilities or economic profits. So if states participate more in the activities under the BB&J framework and have more economic profit, they can receive more benefits, at least as it's formulated right now. So we have some sort of, again, similar to the boundary delimitation, we have distributive justice based on claim or participation or proportionality. So in this case, we have a similar conclusion to maritime boundary delimitation with some additional aspects because we have the non-monetary benefits. So we have distributive justice based on contribution or participation in this case. We have also an aspect of equity as inequality, which was rejected in boundary delimitation. But we also have some elements of corrective justice because, again, at least formally, the rights and interest of developing states should be taken under consideration. And now we have some sort of, at least initial or theoretical model for benefit sharing. And this analysis tried to see if this model fits in the application in the context of the area. And here again, I have to say some caveats because we have no exploitation yet. We didn't reach this stage. So we don't have a practice concerning benefits sharing, and we don't have a case law. But we have the comparison to the previous regime we discussed about, and here maybe drawing some conclusions regarding the application in the context of the area, at least how the modality should look like. So how do we imagine, or how UNCLOS imagines division standards under the common heritage of mankind principle? We have several options because common heritage of mankind implies joint ownership of the resources. Every relevant actor, states or also non-state actors, and putting aside the question of the beneficiaries, we have several options on how joint ownership could look like. So one option is the equity is equality. Everyone is under joint ownership has equal rights and access to the benefits. And here, this is a problematic implementation because this concept has been rejected in the context of the continental shelf, which also refers to non-living resources similar to the area. So that might be a problem to implement in this context. We also have a corrective justice possibility, meaning the interest of developing states should be taken into consideration. And at least some scholars or practitioners claim that it means that only developing states should receive benefits. There is such an interpretation in the discourse. But again, corrective justice, at least in the previous practices, has been rejected, certainly as a sole justification or modality for distribution. So again, we might have problems implementing this interpretation. And we can also have or try to apply the previous practices we discussed, meaning distribution based on claim or contribution with some elements of corrective justice. And the question is it a possibility in the context of the area? We do have officially or formally, we have a preferential treatment for developing states. Their interest should be taken into account. Some even claim that only their interest should be taken into account. But we have the 1994 agreement, which downplays this aspect or this obligation. First of all, we have parallel systems of exploration right now, but it also should be on exploitation, meaning that every state sponsoring a deep sea mining operation also have to contribute or have reserve an area for the operation of the ISA for the benefits of developing states. And this was an obligation in UNCLOS, but in the 1994 agreement, it was reduced to a voluntary operation. Again, reducing or narrowing the rights of developing states or their ability to participate in the activities. We have organs of the ISA which should have been established by now, like the enterprise or the technical, there's committees that should be established and facilitate sharing of benefits also in mind with the developing states' interest. And again, the fact that these organs has not yet established reduces the ability of developing states to participate in the regime, in the activities. And of course, their benefits consequently are also might be reduced. And the last thing, and I mentioned it before, the 1994 agreement reduced the ability for technological transfer for the developing states. The agreement says that developing states should acquire such technologies under the conditions of the market rather than receive it in preferential conditions. And we also have a compensation fund, which is supposed to help developing states, but it's also became voluntary rather than obligatory. So in practice, the corrective elements already existed in UNCLOS have been reduced by the 1994 agreement, which goes beyond further than other practices or other legal regimes on the law of the sea, which might imply that, at least in the context of the area, the benefit sharing should be based on solely or majorly on distributive justice based on contribution or economic profit or claim, which of course has advantages for more powerful states or more rich states rather than developing states. So the question is, if this is the conclusion that we can reach, is it fit with the proposals or the modalities already existing in the discussion within the ISA for distribution? So we have two modalities proposed by the research of the ISA. The technical study number 31 is the famous of them, but there are also other materials based on this proposal. And we have one is the direct payment to states. And here there are several applicable criteria for division, mostly relying on wealth or population. So in both modalities, it means that developing states, or rather than states with larger popularity, but not necessarily participating in the activities, might receive more benefits than states sponsoring the activities. And these proposals does not seem to correlate with the practice we described so far, which is the maybe theoretical modality for this distribution. The second option that we have is the ISA Sustainability Fund or Common Heritage Fund. There's different names now, but it's basically means that benefits should be accumulated in certain fund for the benefit of all. And the funds will, or the sustainability fund will be in charge in investing in certain activities and certain benefits. For example, restitution of the environment, knowledge, or other investments, which depend that there's no decision, but there are several theories on what the fund should be used for. The fund should be at least proposed to govern by the ISA. And as I mentioned, it should be used for various purposes, such research, capacity building, and rehabilitation of the environment. And again, this is pose some challenges in light of the modalities discussed before regarding benefit sharing. So first of all, we have outside uses that reduce benefits for sharing. So if the fund supposed to finance, for example, liability claims, or supposed to finance obligations for the ISA as proposed in its study, then it reduces the benefits left for sharing, and this is outside its capacity altogether, and certainly does not fit with the modalities discussed until now. We also might have an assessment problem to see how much each relevant party enjoyed the benefit or received the benefit or has access to the benefits. And there's also different benefits that might also go to only one or a few of the parties. For example, capacity building is mainly for developing states, which means that other states and other actors might not enjoy the benefit altogether, which again goes beyond the competences laid out in UNCLOS and the 1994 agreement. And there's also a conflict of interest, an inherent conflict of interest, because the ISA has to approve deep sea mining operation, but it's also in charge of distributing the benefits from such activities. And this might also have a challenge for the modalities adopted by itself. So just to conclude the discussion, we have a legal regime that does not provide critical or practical rules for how to divide the benefits from deep sea mining, assuming that there will be deep sea mining and there will be benefits from it. We have general obligation for equitable sharing of benefits and interest of developing state that must be considered, although we discussed that in practice, the last part of this sentence might not actually occur or may not be implemented. And we have, based on other practices within the law of the sea framework, equitable might mean division based on contribution or claim, which means proportionality division, while also ensuring at least some access to the benefits. And here we have some element of corrective justice. But again, in the context of the area, this element might be reduced and render moot altogether. And the last conclusion that we can draw, that the existing proposal mechanism for distributions do not fit with the practice on the conceptual theory or the existing modalities for benefit sharing and distribution of wealth under the law of the sea framework. So thank you very much. I'm concluding this part of the presentation. I give Vidi the floor.
Thank you very much, Shani. It was very interesting and stimulating for us. And so I don't speak too much. I ask if anyone have a question. Yeah, I have.